We're going to pick up in today's class session where the Tuesday class session left off, but I do want to I cannot multitask. I apologize. Bear with me for just a second. That's what I need. That and that and that and that. Okay, so we are going to, as I said, pick up where the Tuesday class session left off. But I do want to take a moment just to sort of refresh your memory. I know you've watched the video that was uploaded for you. If you didn't watch the video, you still have a little time to do it before it expires at the end of the week. But it really is ideal to do the Tuesday session before you come to the Thursday session, because we build in the Thursday class session, we build on what we said in the Tuesday class session. Okay, so we started with just by identifying the several provisions of the Bill of Rights that are relevant, I should say, to our discussion on the rights of the criminally accused. The Fourth Amendment provision against unreasonable searches and seizures and the requirement of the search warrant. The Fifth Amendment, there's a lot of stuff. Remember, there's a lot of stuff in the Fifth Amendment. The part that we're particularly interested in is the protection against self-incrimination. The Sixth Amendment, the right to a speedy, public, and impartial trial, and the right to counsel. And then finally, the Eighth Amendment provision against cruel and unusual punishments, which we're going to get to in today's class session as well. All right, from there, we move to a discussion of the 14th Amendment. And we said that the 14th Amendment is important because most of criminal law falls under the jurisdiction of state and local governments, right? The police power, as we refer to it, the power to protect public safety and morals, is really a power of the states. And while we do have federal criminal law, and therefore federal law enforcement agencies and federal criminal trials, it is a fraction of the total criminal cases that are generated in this country. Most of them, as I say, are most arrests for criminal conduct are done by state or local law enforcement, mainly local law enforcement. Most trials are conducted in state trial courts, right? Why are these provisions of the Bill of Rights relevant? Because the Supreme Court, you just had a question on this on the quiz that you took, right? Because the Supreme Court of the United States has said that these are rights that all Americans have, regardless of whether they live in Texas or whether they live in New York or California or whatever the state is that they live in. You have a right to be secure against unreasonable searches and seizures in your person, papers, and houses and effects, right? You have a right against self-incrimination. You have a right against or to a speedy and impartial trial and a right to counsel. So those are rights that belong to the individual regardless of what state they live in. However, the Supreme Court can't just say, that these ought to apply to Americans against the authority of state and local governments just because they think they ought to. There has to be something in the Constitution that allows them to reach that conclusion, and the answer is the 14th Amendment. Particularly, what part of the 14th Amendment? The Due Process Clause. That's the part that says no state. That's pretty straightforward. It could be Texas, it could be Idaho, it could be Florida, whatever the state is. No state shall deprive any person of liberty without due process of law. The only real question is, what does that word liberty mean? And the court has, over a period of many, many decades, told us that it includes most of the provisions of the Bill of Rights. They've never said everything in the Bill of Rights is a fundamental right of the individual, a fundamental liberty of the civil liberties right of the individual. But over the course of 100 or so years, in a piecemeal fashion, on a case-by-case basis, the court has said, the right of free speech is a fundamental civil liberties right of the individual. The right of free worship is a fundamental civil liberties right of the individual. The right to keep and bear arms, fairly recently, within the last 12 years or so, the Supreme Court has said that's a fundamental right of the individual and therefore protected against the authority of the states. In about the middle part of the 20th century, 1940s, particularly the 1950s and the 1960s and into the 1970s, the Supreme Court begins to say that the right against unreasonable searches and seizures is a fundamental right of the individual protected against the authority of the state. The right against self-incrimination is a fundamental. The right to counsel is a fundamental right of the individual. So through the 14th Amendment's due process clause, that concept of liberty now also includes these things. And we haven't talked about it yet, but also the guarantee against cruel and unusual punishments. We'll get to that in today's class meeting. Okay? So, you know, again, as I told the Tuesday class, I understand that this is not a law school course, okay? And I do understand that the doctrine of selective incorporation is a bit of a sophisticated idea, but it is very important for us to understand, even in an introductory course. In fact, I would go so far as to say, even if we're not in an introductory course, even if we're just Americans, right? We kind of need to understand that these fundamental civil liberties rights that we're talking about here that may be at issue if you deal with the police are protected against the authority of the state through the 14th Amendment due process clause. Okay? Questions about the doctrine of selective incorporation? That was something that we hit on in the Tuesday class session, developed a little bit, but just to give you an opportunity here, if you weren't quite clear after watching that video from the Tuesday class session, now's a good time to get some clarification. Okay, well, once we talked about the provisions of the Constitution that are relevant, then we moved on to a discussion of some case law. Got to get to the right spot. Bear with me here for just a second. We moved on to some case law, and we started with the exclusionary rule. Okay, we got so far as talking about the Weeks case. That's the case, initial case. This is the first case where the Supreme Court articulates the exclusionary rule. It goes back over 100 years now, where the Supreme Court said that evidence obtained by law enforcement in violation of the Fourth Amendment provision against unreasonable searches and seizures and the requirement of a search warrant are not admissible in court to obtain a conviction against the defendant. Okay? But that was a case that involved federal law enforcement. It took another half century for the court to apply the exclusionary rule to state and local law enforcement. And that's this case, Mapp versus Ohio. Recall that's the case that involved the police arriving. I don't remember what city it was in Ohio. For some reason, I think it's Columbus, and I keep telling myself I'm going to go back and look that up because that's pretty easy to find out the answer. But it could be Cincinnati or it could be Cleveland. Just for some reason, I think it's Columbus. They arrive at the home of a woman named Doltree Mapp and serve a search warrant that says that they're looking for evidence in a bombing incident. They don't find any evidence in the bombing case, but they do find materials that they determine are obscene under Ohio law. And so they arrest her. She's put on trial. She's convicted for violating Ohio obscenity law. And she appeals the conviction on the grounds that the search warrant didn't specify anything about obscene materials. It said a bombing incident. And the Supreme Court agreed that the requirement of the Fourth Amendment, remember that language of the Fourth Amendment says specifying the things to be searched and the person or things to be seized, right? So this is an important case because not only is the Supreme Court upholding that principle, but they're also saying that the exclusionary rule is applicable against state and local law enforcement.
Right.
Yes, sir.
What evidence did it find?
I don't remember. I've never really looked into the case in that kind of detail. You know, local jurisdictions, state and local jurisdictions have different laws on obscenity. Okay. So, you know, what they may have decided back in the early 1960s, what they might have defined as obscene under Ohio law might have been different than what Texas would have defined as obscene, but it might even be different than what they would define as obscene today. So I just don't know the answer to that question. But again, it might not be that hard. If you're curious, it might not be that hard to find out. You know, the internet does allow us to do that kind of stuff if we're interested. And then we talked a little bit about the fruits of the poisonous tree doctrine. This is from the Tuesday class meeting. Okay. So again, if you don't remember what that's about, maybe go back and look at that part of the video again. we got as far as talking about some of the exceptions to the exclusionary rule. We talked about this case, U.S. versus Leon. That's the case where the Supreme Court said that evidence obtained by the police when serving a search warrant in good faith does not necessarily have to be excluded just because there might be some mistake with the warrant. The case itself, again, I'm not going to go into all the detail that we went in on Tuesday, but let me just refresh your memory. The case involved FBI surveillance of a man by the name of Alberto Leon. They thought he was doing drug trafficking, and they went to a judge and asked for a warrant. They provided, what do the police have to do? In this case, the FBI, what do they have to do in order to get a search warrant? Well, they have to establish probable cause, which means what? They have to convince the judge that there's a high probability that they're going to find, when they conduct the search, that they are going to find what they say they're looking for, right? And the judge accepted it and signed off on the warrant. They served the warrant, they conducted the search, they gathered the evidence. The defense attorney for Alberto Leon moved to suppress the fruits of the search on the grounds that the evidence that the police presented to the judge who signed off on the warrant was not sufficient to establish probable cause. Apparently there's some standards in the law enforcement community and among, in judges for what constitutes sufficient evidence to establish probable cause. And I don't know the specifics of that, why this didn't meet the threshold. But the trial judge agreed. Understand that the trial judge that we're now talking about, who's entertaining this motion, is not the same individual who signed off on the warrant. Okay? The trial judge says, you know what, you're right. That judge should have never issued the warrant because there was not sufficient evidence to establish probable cause. The motion is granted. The evidence is going to be suppressed at trial. The government appealed that decision, and the United States Supreme Court on appeal said it doesn't necessarily have to be suppressed. And in this case, it should not be suppressed because the police were serving what they believed to be a valid warrant. The police were not, the purpose, they said, the Supreme Court said in the Leon case, of the exclusionary rule is to prevent the police from flaunting the provisions of the Fourth Amendment, to prevent the police from willfully violating the Fourth Amendment. They believed what they believed was a valid search warrant. They served that warrant. They followed due process. The mistake was that on the part of the judge who issued the warrant, and the police should not be punished in this sense for the mistake of the judge. Okay, so that's the first very important exception to the exclusionary rule that's handed down by the court in 1984. And again, why is 1984 a critical year? Well, remember the footnote from the roundtable discussion program, right, where the voice comes on and says in the 1984 term, the Supreme Court handed down some decisions regarding exceptions to the exclusionary rule, blah, blah, blah. They recorded that panel discussion program after they recorded the panel discussion program, but before it went to air, the Supreme Court handed down a couple of very important decisions. One of them is this Leon case. Notice the date, 1984, which is the same date that the same year that the program was recorded. Okay. There's another one that we'll talk about here in just a second. Okay, or that I'll remind you of it here in just a second because we talked about in the Tuesday class meeting. Okay, but any questions about that good faith exception to the exclusionary rule? So up until 1984, up until the mid-1980s, the general drift of the court's decisions are to protect, to provide greater protection for the rights of the accused. But beginning in the mid-1980s, we start to get a series of decisions that really make it easier for the police to do their thing. It's kind of as I like to describe, kind of a pendulum, right? In the middle part of the 20th century down to the middle part of the 1980s, the pendulum is swinging in the direction of the rights of the accused. From the middle 1980s really down to the present, the pendulum has sort of been swinging back towards, making it easier for the police to do their investigations and easier for the prosecutors to get convictions. So the other exception that I mentioned in the Tuesday class session was this one, the harmless error exception. That comes from also a 1984 decision of the Supreme Court in a case called Massachusetts versus Shepard. And again, not going to go into all that detail again, just to refresh your memory. This involved an error on the part of the clerical staff on the judges in issuing the warrant. Okay, so the police go to the judge and ask for a warrant, and apparently there was some information that was incorrect, and the judge's clerical staff was supposed to change the information, but they never did it. So we have kind of a technical error with the warrant. And up until 1984, that would have been grounds for dismissing or for suppressing the evidence obtained in the search. But now the Supreme Court says in Massachusetts versus Shepard, not necessarily, right? That in fact, it may have been a harmless error and doesn't have to be suppressed. In fact, in the case in question, it was suppressed. It wasn't suppressed. Okay. So questions about that? I've also indicated here, this is kind of where we left off in the Tuesday class session. I indicated that in a similar vein, the Supreme Court has ruled that the exclusionary rule does not apply when the police, through an honest mistake, find drugs while searching the wrong apartment, or where a computer error showing an outstanding arrest warrant on the wrong person leads to a search of a vehicle that turns up evidence used to arrest and convict that person. Again, you get the drift of these decisions of the court, right? The police make mistakes. Sometimes that doesn't necessarily mean that evidence is going to be suppressed. I have a little note here. I want to share this with you. Sometimes I get very interesting feedback from students and questions that students ask. This comes from this is a discussion thread from an online class a number of years ago. This is fall of 2014. This is getting to be almost a decade old now, but I think it's interesting, and I think you might find it interesting, and if not interesting, at least kind of enlightening. Okay, I had a student who put a question on the discussion board asking this. I'm a little confused about the warrant process. If, according to the exclusionary rule, a warrant has to be specific, how can law enforcement happen upon a crime accidentally and still use the evidence at trial? Are the rights of that individual not violated? And my response to that is, I'll get you a little bit bigger look. No, I can't. It won't blow up. Anyway, hopefully you can read this. My response to that is, well, keep in mind 2 points. First of all, there are a few areas of our law that are as murky, even for prosecutors and defense attorneys, as the rights of the accused, particularly the question of what the Fourth Amendment permits with respect to searches and seizures. You can get different answers to questions depending on who you ask. And boy, I tell you what, I can testify. I'll testify in court to that. I've asked these questions of different people, like who are in the profession, defense attorney, people who are in the area of criminal justice doing work, and you get very different answers to a lot of the questions that you can come up with. The second point is I'm not a lawyer, so I never pretend that I know the definitive answer to a question. But here's my best attempt. Warrants are not required if the police observe a crime in progress or in cases of hot pursuit. You're probably aware of that, right? You're already aware of the fact that the police are pursuing a suspect who's observed in the commission of a crime, or they suspect is committed a crime. And this person eludes the police by ducking into their house, let's say, and closing and locking the door behind them. They don't have to go stop their pursuit and go get a warrant at that point, right? They can just bust down the door and go. That's called the hot pursuit doctrine, and it's an exception to the exclusionary rule. Or I should say, to be more precise, it's an exception to the requirement of a warrant. They don't have to get a warrant in that case, okay? Or in those kinds of cases. Also, the rules may differ when we are talking about arrest warrants as opposed to search warrants. I'm not sure if I'm answering your question very well. If not, perhaps you can be a bit more specific. Well, before she could respond to that, I had another student who chimed in, monitoring the discussion board. Here's what she added. She said, Paula, my husband, who is a criminal justice major, said that there is the plain view doctrine that officers go by. If law enforcement officers can see evidence of criminal activity prior to entering or in an initial search, then the officer has the right to enter without a search warrant. If an officer sees a weapon from a legal vantage point, he is allowed to proceed with the search. This is applicable to homes and vehicles. He looked it up in his book. Well, that's a good source, right? Look it up in your book. No, I mean, it's right. This is absolutely right. There is a plain view doctrine, and it is, an exception to the warrant requirement. If the police pull you over, for example, you're in your car, and they pull you over and they say, I'm going to search your glove box, right? Do they have to get a warrant for that? Yeah, they do. Or your trunk, right? Right. And why is that the key point here, right? Why is it that you say because your glove box is closed or your trunk is closed?
Well, because since those things are closed, it's not plain view.
And there's a presumption of privacy. That's the part. You're absolutely on the right track. I just wanted to get you to say those words. There's a presumption of privacy. That's going to become very important for us as we continue to talk about this. That's essentially what the court's looking at. Is there a presumption of privacy? If you put whatever it is in your glove box and close the glove box, you are presuming that there's privacy there, or in your trunk. If you leave it on the car seat next to you, the passenger seat, there's no presumption of privacy there, right? Anybody who walks up to your car window, whether a police officer or not, can see it. So there's no expectation you have a privacy there. So the police don't have to get a warrant in that case. Okay. Anyway, he looked it up in his book, so it must be, books are generally right about that kind of stuff. Well, I guess depends on the book, right? But the original student then replies, I guess what troubles me is this ruling. The Supreme Court also ruled that the exclusionary rule does not apply to evidence that is obtained by honest mistake. For example, searching the wrong car and finding evidence, or the wrong apartment and finding evidence. I guess I should have asked, how can evidence accidentally discovered be admissible in court considering the specificity of the Fourth Amendment and the exclusionary rule? It seems to me that if the Fourth Amendment states, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized, then evidence accidentally found should be suppressed. Who defines honest mistake? I think she's asking great questions. Right? So anyway, here's my effort to answer her question. She's doing a better job asking questions than I am answering. The answer to your last question is the presiding trial judge, who must take into account the circumstances of the specific case, decides whether the police error was a willful violation or an honest mistake. That's the debate that some of the participants in the panel discussion program were having near the end of the program. I am certainly not defending the logic, but I think it goes something like this. The exclusionary rule was devised by the Supreme Court as really the only feasible means of preventing law enforcement from flaunting the requirements of the Fourth Amendment and willfully conducting warrantless or otherwise improper searches and seizures. If the evidence is accidentally found by the police as a result of the search of the property that doesn't even belong to the suspect that they are investigating, the search could not qualify as a willful disregard of the Fourth Amendment. It would be more like the police just happening onto the commission of a crime in progress. Again, not a lawyer. She wasn't satisfied. I guess more than a question, I was commenting on the accidental findings. I understand if a police officer happens upon a crime in progress, let's say for the sake of argument, a bank robbery, it would absolutely go without saying that the police officer should act. However, what I was referring to was, let's say you were at home and there's a police raid of your home, but the warrant lists your neighbor and specifies, say, illegal guns or whatever. Instead, the police make a mistake and come to your house instead. Let's say you have in your home medicinal marijuana or whatever. How are they going to justify the lack of a warrant with a specific address and specific items to be found? I guess my point is that the person who happens to be searched because of a mistake has lost his right to the reasonable expectation of privacy, as the warrant issued does not include his address or the items accidentally found. It's kind of scary. Not that I would break the law, but tyranny is really ugly, and I'm concerned that this sort of thing could get out of hand. I know there is not much a common citizen can do about that, but if I were the one to be invaded by police by accident, I would be shouting my rights have been violated. That does not change the fact that I would still have to go through the whole legal process. If I'm off base, please let me know. All right. Here's my response. Right? I understand your point. What I was inelegantly attempting to suggest is this. The courts seem to be mainly focused on whether the police willfully violated the search warrant requirement of the Fourth Amendment, not on whether the person who was named in the warrant had the privacy of his or her home violated. I'm certainly not disputing your concern. I believe it's a valid one. No one is a greater proponent of the right to privacy than boy. No statement has ever been truer said. I am a great advocate of the right to privacy. In general, I agree with the assessment of Justice Louis Brandeis that the right to be left alone is the most comprehensive of rights and the right most valued by civilized men. However, all of these cases in the area of criminal due process, indeed in the broader area of civil liberties rights, ultimately come down to a matter of line drawing. Because the U.S. Constitution and the Bill of Rights are not crystal clear on these matters, in specific cases and circumstances, the courts have to determine where the line should be drawn between protecting the rights of individuals on the one hand and permitting the government the authority necessary to assert the state's compelling interests, in this case maintaining order, on the other hand. For most people, just a tweaking of the facts of a case can lead them to conclude the line should be drawn in different places. Consider a variation of your hypothetical scenario. I've pasted your scenario below and just changed a few words that are highlighted. So the words I'm about to share with you were written by her with one exception. Okay? Let's say you are at home and there's a police raid of your home, but the warrant lists your neighbor and specifies, say, illegal guns or whatever. Instead, the police make a mistake and come to your house instead. Let's say you have in your home a dismembered human body. She said medicinal marijuana. Both illegal in Texas, right? Or whatever. She did say whatever. How are they going to justify the lack of a warrant with a specific address and specific items to be found, etc.? So, you know, I wonder, I should have asked you before I put this up there. I mean, how many of you would draw the line differently? Is this different? Whereas you might have said in the case of medicinal marijuana, no, the police shouldn't be able to prosecute you if they came to your house accidentally, and you know that. But how about a dismembered human body? Oh, now I look at that a little bit differently, some people might say, right? And that's what I mean about the issue of line drawing. The courts are going to have to decide where to draw the lines in these cases. I know that we want very definitive answers to these questions. We would like for it to be just this or that, you know, black or white, no shades of gray, right? But these areas are murky, and it's really hard to know what the answer is until the courts actually deal with that question, deal with that case. Okay, so that's basically what I said. In addition to that, I shared some information with her about what one of my friends who's a lawyer, a defense attorney, says that people should do if the police come to their house or, you know, their residence or whatever and say they have a warrant, you know. Although, you know, and I'll shoot these off to you if any of you are interested in these. I'm not going to read through them with you here in class, but I will concede, you know, that some of these points, you know, lawyers say things like this, but it's easier to say than do. When the police are standing in front of you with full tactical gear on, right, and they say, we've got a warrant, we're coming in, it's really, really hard to assert your rights.
Do you have the right to read the warrants?
Yes, you do. But that doesn't mean before they come in. I mean, yeah, oh, sure, here's the warrant, and, you know, they go in. Right? I mean, they're going to blow past you. Right? It's even hard, I think, when if the police come without a warrant. The police say, hey, come on, we want to look around. I think it's hard in that situation for regular people to say, no, you're not coming in. I told the police officer once he couldn't search my trunk. I had nothing in it. Should have let him. I just didn't. But I wanted to make him jump the hoop. Right? And he just left. He didn't.
like you said, the line drawing is different. If it was a different shade of color or a different situation, it might have been a lot different.
Yeah,
Yeah,
I do. I think it does matter a lot what the specifics are. It's really hard, even as, we're not Supreme Court justices, right? We're just regular people. But when you start thinking about these kinds of issues in that way, you kind of, most people come to, yeah, it's not as simple as, we think it's going to be. Okay. Anyway, I thought you might find that discussion interesting. So let's move on, though. We've got some other things we need to talk about. Let me get back to the right spot. Okay, so we've talked about, let's touch on these real quick. We talked about the hot pursuit doctrine. We've also talked about the harmless error doctrine. Let me share this one with you. This is the inevitable discovery doctrine. Again, these are exceptions to the exclusionary rule. Okay, so actually, before you get too busy writing this stuff down, let me give you the context again. Up until about the mid-1980s, the practice was, if there was some problem with the warrant, or we could also take it into the area of statements, right? If the Miranda was not administered, or if Miranda was administered improperly, or something like that, it was just an automatic, right? That the exclusionary rule was going to apply, right? That the trial judge was going to say, no, this evidence, be it statements or be it physical evidence, is going to be excluded at trial. That begins to change in a big way in the mid-1980s. And here's a case, Arizona versus Fulminante, which is actually decided by the Supreme Court, I think in 1990 or 1991, or it could be like 88 or 89, somewhere late 1980s or early 1990s, where the Supreme Court develops this inevitable discovery doctrine that says that even if there was a problem with the warrant, or presumably if there's a problem with the statements, they do not necessarily, the evidence does not necessarily have to be suppressed. It doesn't necessarily have to be excluded at trial. If the government can demonstrate to the satisfaction of the presiding judge that the police or the state, the government, would have come to evidence by employing alternative law enforcement means, investigatory means, that would have been sufficient to secure a conviction. You understand what I'm saying? Let's say as an illustration, the police have a statement from somebody that's tantamount to a confession, very incriminating statement, but they didn't administer Miranda, or they didn't do it properly. Up until this time, it would have been automatic, okay? But here the Supreme Court is saying not necessarily. If the government, if this prosecution can demonstrate that they would have come to evidence, they would have been able to get evidence sufficient to secure a conviction by other law enforcement means, these statements made by the suspect do not have to be suppressed at trial. They can be admitted as evidence. Or if we're talking about physical evidence, the physical evidence can be admitted. Does that make sense? Okay. So there's another exception to the exclusionary rule. The attenuation doctrine and the independent source doctrine are very similar. In the interest of time, I'm going to forego those. They're sort of very related. If you're interested, you can do a quick Google search of the attenuation doctrine or the independent source doctrine. Bottom line is they are exceptions to the exclusionary rule. Okay? Questions about that? I know I'm starting to rush a little bit here, but I want to make sure we get some things in. All right, let's move on to the right to counsel. I'm going to put these two cases up. I'm going to deal with the Escobedo case first. Okay? I think you'll see why here in just a second. Even though in the order of time it came second. This case involved a man by the name of Danny Escobedo, who was being interrogated by police, reportedly for a very extended period of time. I mean, I don't know exactly. I don't remember. It's been too long since I've looked at the details of this case. But we're talking over a period of hours at least. And I imagine, like, maybe I've watched too many crime dramas, but I imagine like teams of detectives coming in, tag teaming, right? Like the detectives come in and they ask the questions and they don't get answers that they want. And so another team of detectives comes in and starts asking questions. Maybe they play not, good cop, bad cop kind of thing, right? All the while, as this is going on, Danny Escobedo is asking to see his lawyer. And the police keep telling him, you'll get to see your lawyer when you confess. And after many hours of interrogation, he finally succumbs to the duress and confesses. On the basis of that confession, the state of Illinois secures a conviction against Escobedo. He appeals his conviction, arguing that he invoked his right to an attorney and the police should have allowed him to have his attorney. And the Supreme Court says, you're right, they should have. And so the conviction was overturned on the grounds that the statement should not have been admitted as evidence. Okay? So this is really the lead case in the right to counsel area. Although Gideon versus Wainwright's a very important case too. How many of you like film? How many of you like cinema? You like classic cinema, like golden age of Hollywood kind of. Have you ever seen the movie Gideon's Trumpet? You have seen it. Okay, good.
Watched it in my senior year.
Okay. The one with Henry Fonda? Okay. It won an Academy Award, pretty good movie. I've never seen it, but I'm given to understand it's a pretty good movie. Why would Hollywood make a movie about this guy, Clarence Gideon? Well, let me tell you what the case involves. This guy named Clarence Gideon was a petty criminal, a petty thief in Florida. You know what his gig was? It was busting into pool halls and breaking open cigarette machines and stealing the coins out of them. In those days, they used to sell cigarettes out of vending machines, just like you can buy, soft drinks out of vending machines. They don't do that anymore. That hasn't been a thing since like the 1990s. Have any of you ever seen a cigarette machine? Now, I think it was part of the settlement of the tobacco lawsuit that several states had against the tobacco companies, that they agreed not to sell cigarettes in vending machines. Because kids obviously can put money in vending machines too. At any rate, that was his thing. He was busting these machines open. Well, he got caught, and the state of Florida puts him on trial, and he asks to have an attorney appointed to represent him. But the state of Florida denied the request, saying that they only provided counsel if it was a capital case, if the death penalty is on the table. And this is not a capital case, right? So he acts as his own attorney. He defends himself, and he's convicted. No surprise there, right? He's sent to prison, and I think this is the part that makes the story appealing to Hollywood, that they would make a film out of it. Using the prison library, he researches the case law and writes his own appeal to the United States Supreme Court. And the Supreme Court grants certiorari and reviews his case. And the Supreme Court holds that in felony cases, the defendant should be provided with a lawyer by the state if they can't afford to pay for the lawyer themselves. And that's probably something you already knew, right? You already knew that if a person is, accused of a felony and they can't afford to pay for a lawyer, that the state has to provide them a lawyer. Okay? But that's where that comes from. This is where that comes from, the Gideon versus Wainwright case. Okay? All right, a couple of other cases here real quick. Now, notice the year on these, okay, 1963 and 1964. That's smack dab in the middle of that period that I told you that the court is handing down decisions that are favorable to the rights of the accused, correct? But the pendulum begins to swing beginning in the middle 1980s. And so here we have a 1990 case, and you might be thinking, oh, we might get a different thing here. But actually, this is kind of an exception to that, okay? This case involved, I'm going to resist the temptation to click on this one, just give you the real sort of brief version of this case. This case involved the state of Mississippi essentially made the claim that it was only required to allow a accused person to consult with their lawyer once, after which they can interrogate the suspect as much as they want without the lawyer present. That was what the state of Mississippi's policy was. Okay? And this guy was convicted on the basis of statements made during those interrogations, and the case was appealed to the United States Supreme Court, and the Supreme Court said, nope, you're wrong, Mississippi. Once the suspect invokes their right to counsel, that remains in effect until they revoke it, right? If you've ever watched, Law and Order or, program like that, maybe you've seen an episode where the suspect decides that they're going to cooperate with the police, and then they always have them sign a form that says, I'm, revoking my right to counsel, to have my lawyer present. So that's an important case there as well. This is moving to this, these self-incrimination cases. This is the lead case involving the Fifth Amendment right against self-incrimination. The case involved a man by the name of Ernesto Miranda, who was tried and convicted on kidnapping and rape charges. The only evidence that the state of Arizona presented at trial was a confession. Very quick trial. And on the basis of that confession, and only on the basis of that confession, he was convicted. He appealed his conviction on the grounds that he didn't know that he had a right to remain silent. The police should have told him. And the Supreme Court agreed. And this is the case where the Supreme Court imposes on law enforcement the affirmative responsibility of informing the suspect of his or her rights under the Fifth and Sixth Amendment, the right against self-incrimination and the right to counsel. Now, the state of Arizona did retry Ernesto Miranda. His conviction was overturned, but now they go do some police work. They gather some evidence. They know they're not going to be able to use the confession. So they go out and do some police work, whatever that involved, physical evidence, maybe eyewitness testimony or whatever. They put him on trial and he's convicted. And he serves a prison sentence for kidnapping and rape. Okay? But he's ultimately paroled by the Arizona Board of Pardons and Paroles, whatever they call it. And he's in and out of prison for a number of offenses over the next few years. He made his living by selling Miranda cards, autographed Miranda cards. In those days, I guess the police needed a little help. Right? So they would carry these cards around with them when they placed a suspect in custody, reading the rights. So you have a right to remain silent, you have a right to things they get of you. So they would just read that with these cards that were printed up. Somehow Ernesto Miranda came into a supply of these things, and he would autograph them and sell them. That's how he, I guess, paid the bills. He was eventually knifed to death outside of a bar in Phoenix, Arizona. And when the police arrived at the scene, they found his body with a Miranda card pinned to it, which raised lots of questions about who might have killed Ernesto Miranda. To my knowledge, they never even identified a suspect in his murder. I could be wrong about that part of it. I just don't remember it. Anyway, so if you're a believer in ultimate justice, maybe some people would say, well, he got what he deserved. Right? Anyway, that's the important part of it for our purposes. Is just that this is the case where the court says the police have to inform the suspect of their rights. Otherwise, as you heard one of the judges in that panel discussion program say, well, the police don't have to do it. It just means that whatever statements they get are not admissible in court. Here's the Arizona versus Fulminante case again. Remember we talked about that up here in connection with what? Does anybody remember? It's this business here, the inevitable discovery doctrine. Okay. So what year is that? 1991. This is a big one. This talking about that pendulum swinging in favor of law enforcement, this is like a huge jerk of the pendulum in that direction. It actually involved the case in question actually involved a coerced confession. The police beat a confession out of the suspect. And the Supreme Court says here in 1991, it doesn't necessarily have to be suppressed. It doesn't necessarily have to be excluded at trial. If the prosecution can demonstrate that they would have found other evidence via other law enforcement means that would have been sufficient to lead to a conviction, the confession can be introduced as evidence. So imagine how professional defense lawyers might have reacted to this decision back in 1991. Or law enforcement, for that matter, how they might have reacted to that. This is also a very interesting case, 1990, Dickerson versus the United States. This case was watched by people in the news media, people who followed the area of criminal justice, and indeed the general public was followed pretty closely. There was a lot of anticipation about the Supreme Court's decision in this case because many people argued that this would be the case where the Supreme Court would overturn Miranda versus Arizona. You know how there's, you know what Roe versus Wade is about, the abortion decision? You know there's a lot of discussion right now in the news about a couple of cases that the Supreme Court is hearing this term in 2022 dealing with the abortion question. And a lot of people are speculating that one of these two cases may be the case where the Supreme Court overturns Roe versus Wade. Have you heard this kind of discussion? Okay. So it's very similar back in 1990, right? People are following this case and they're saying, this might be the case where the Supreme Court overturns Miranda versus Arizona. And one of the reasons that people had that idea was because the Chief Justice of the United States, William Rehnquist, was on record as being a harsh critic of the Miranda decision. He had written extensively about the flaws of the Supreme Court's decision in the Miranda case. And so why not conclude that, under his leadership, the Supreme Court will overturn Miranda? Well, they didn't overturn Miranda. But, in fact, they upheld it. But it's really like a completely different issue that it turns on. So this case goes back, really, the origins of the case go back to 1968. When was Miranda? 1966, okay? So a couple of years after the Supreme Court's decision in Miranda, the United States Congress decides to pass a law in which it says that confessions, only coerced confessions are to be suppressed in the absence of Miranda. But the law went untested for several decades until 1997. That's when this case arose. Dickerson was indicted for bank robbery. He argues at trial that some statements he had made to the FBI were made without the benefit of Miranda warnings and that they should be suppressed. But the Supreme Court sort of skirted that issue altogether. I mean, they did affirm the Miranda warnings, but essentially what the court said in this case was that Miranda versus Arizona is the law of the land until the Supreme Court reverses it or until we have a constitutional amendment. That Congress cannot overturn a Supreme Court decision by ordinary legislative act. In other words, they saw it as a separation of powers issue. So that's kind of an interesting case. We'll have to see in the years to come whether the current court is going to hear a case dealing with the Miranda warnings and whether they overturn them. I wouldn't be shocked if we get a case in the not too distant future where the current Supreme Court directly takes up the question of Miranda, just like some people are suggesting about the abortion question in Roe versus Wade. This case, Howell versus Fields. This involved a man who was already in prison, and I think on rape, convicted of rape or something like that. It's not a violent crime, certainly. Can't remember specifically, but police go to the prison where he's being incarcerated to interrogate him in a completely different case that they believe he's a suspect in. Okay? And he makes some statements to the police during that interrogation, which are a big part of his conviction in the case. But he argues on appeal that the statement should have been disallowed because he was not Mirandized. And the Supreme Court says he didn't need to be Mirandized. He wasn't in the custody of the police. He was in the custody of the Department of Corrections. And he could have got up and left that interrogation at any time if he wanted to. So Miranda doesn't apply. Okay, questions about any of those? Okay, we only have about 8 minutes left, so let me get as much of this capital punishment stuff in as I possibly can. If we run out of time, I may include for your benefit some material on the website to just kind of wrap these up. Okay, but let me make my best stab at it. Okay, I'm only going to introduce you to 2 cases here. Okay, Furman versus Georgia, 1972, and Gregg versus Georgia. These are actually lead cases. The Furman case is the lead case in this group of cases, one involving the state of Texas. Okay, and the Gregg case is the lead case. Why is that doing that? The Gregg case is the lead case. I don't know why that's doing that. Do it this way. Not going to work. Do it this way. It's one of 5 cases that's decided by the Supreme Court in 1976. Again, one involving the state of Texas. Okay? So here's the thing about Furman. The Supreme Court handed down a decision in Furman, which was widely interpreted by the general public, by people in the media and so on, is that the Supreme Court had ruled the death penalty was unconstitutional. However, the Supreme Court really never said that the death penalty was unconstitutional. Really, what it had created was a moratorium on the death penalty. The Supreme Court did find some problems with the death penalty statutes in Georgia and Texas. And I'll tell you what those problems were here in just a second. But again, the misperception at the time was that the court had said that the death penalty was unconstitutional. Okay? In 1976, there can be no doubt about what the Supreme Court says. The Supreme Court upholds the death penalty statutes of Texas and Georgia, a couple of the other states, just four years after the fact. And of course, the death penalty was resumed at that point. Texas, for example, we know it's not a surprise to anybody, right? We execute people convicted of capital murder in Texas, right? Well, we leave the country, as a matter. Well, we don't use the electric chair. No, we have lethal injections in Texas. Most states, I think, use lethal injections, although I did learn just the other day, I heard a story on NPR. I forgot what state it was. I need to go back and look, but there is still some state that's using the electric chair. It kind of shocked me. I thought that was surprising to me. I didn't realize that there was still at least one state that uses the electric chair. Which I guess a lot of people would argue is cruel and unusual. You know.
It should be against the 8th Amendment.
But the court has never, the Supreme Court has never said that the electric chair is cruel and unusual punishment. To my knowledge, it hasn't even addressed that question, but it has addressed more.
South Carolina.
South Carolina?
One of 8.
Okay. Yeah, learn something new every day, right? At any rate, what is it about these death penalty statutes that the court is reviewing in 1976 that allows the death penalty to be reinstated that apparently wasn't present in the death penalty statutes of these states back in 1972? Let's address that real quick, okay? First of all, Uh, here are the types of crimes that are considered to be capital offenses in Texas. Murdering a police officer or a firefighter is acting in the lawful discharge of an official duty and who the person knows is a police officer or firefighter. That could get you the death penalty. Committing a murder or for pay or promise to pay or employing another person to commit murder, that's a capital offense. Committing a murder while escaping or attempting to escape from a penal institution, murdering a prison employee while incarcerated, committing a gang-related murder while incarcerated, committing a murder to obstruct justice or in retaliation against a witness in a criminal case, committing serial or mass murder, murdering a child under the age of 6. I don't know. I'm going to anticipate a question that somebody may have, because I've been asked this question a number of times over the years. Why the age of 6? I don't know. I guess the legislature over in Austin has determined that it's particularly heinous to kill somebody not at 7. 7's not as bad as 6, right? I don't know why they decided 6, but that's what Texas law says. Okay. All right, so if you have one of these offenses, what has to happen? Or what are the possible punishments that can be imposed? Well, the jury or the judge, if in the case of the judge deciding the sentence, can be either life imprisonment without the possibility of parole or the death penalty. Okay? But in consideration of the death penalty, the jury or the judge must answer these 3 questions, must ask and answer these 3 questions. And this is where we see the effect of Furman. Because essentially what the Furman decision is about is this stuff. The court essentially said in Furman that the way that the states are administering the death penalty is unconstitutional. The case itself involved a man, Furman, who committed a home invasion burglary. And in the course of that home invasion burglary, he says that he thought the house was vacant, that there wasn't anybody at home. But apparently he was surprised. Somebody comes in on him, flips on the light or something like that. And the gun he was carrying, he dropped it and it discharged, fatally killing the person who came in on him. And he argued, therefore, he should not be subject to the death penalty. Under Georgia law at the time, it didn't matter if it was an accident. Under Georgia law, if you murdered someone, if you killed somebody during the course of the burglary, automatic death penalty. And what the Supreme Court is saying is that that's too arbitrary. Okay? So what must they do when considering the sentence? This would be true in Texas or Georgia or anywhere else. Well, was the conduct of the defendant that caused the death of the victim committed deliberately and with the reasonable expectation that the victim's death would ensue? If the answer to that question is yes, it was committed deliberately with the expectation that the person, then you might get the death penalty. If the answer is no, no death penalty, right? Life imprisonment. The second question is it probable that the defendant would commit additional acts of violence that would constitute a continuing threat to society? If the answer to that question is yes, possibly the death penalty. If the answer to that question is no, life imprisonment. Is there anything in the circumstances of the offense and of the defendant's character that would warrant a sentence of life imprisonment rather than the death penalty? If the answer to that question is yes, there is something in the background of the defendant, life imprisonment without parole. Okay. If it's no, possibly the death penalty. All right, so that makes sense. They have in, let me just finish on this point. In most trials you have the trial and then the jury, pronounces guilt or acquits them, right? And then there's a second phase, which is the sentencing hearing, right? So what we're talking about here is the sentencing hearing. You already have a guilty verdict, right? And so now what the jury has to do is weigh these 3 questions in the sentencing hearing to determine which of these 2 sentences is going to apply. Okay? So I hope that helps. That's what the problem was with Furman. Another problem with Furman, which is really a problem that some people, in fact, I don't think it's really a debate. It's pretty clear that this is still a problem. There's a racial inequity in the administration of the death penalty. right? That we know that African Americans who are convicted of capital crimes are much more likely to get the death penalty than Anglos committed of the same crime. There's that disparity in the administration of the death penalty. So some have argued that that issue still needs to be addressed. Okay, we're out of time. We will see you 1 week from today when the topic will be civil rights. No, I'm sorry. I'm in the wrong class. This is not Government 2305. This is Government 2306. What's the topic for next week? The topic is, taxes. Oh, woohoo. Taxes. Okay, yeah, we'll see you Thursday.
You, the NPR thing, according to